3, 2, 1. Dear colleagues, we continue the special session. Broadcast in 1, 2, 3. So we'll continue the session. Is interpretation audible? So the issue of eligibility of Koryahin Vitaliy is being considered in this special session according to the law on High Anti-Corruption Court. Norman Oz, Mary Kay Butler, Robert, Gabriela is now absent, but she will need to join us by video. John Sullivan and Mikhailo Bogonis, Людмила Volkova, Vitaly Gatsenyuk will join us later. Ярослав Дух, Лев Кодисюк, Ігор Кушнір, Руслан Мельник, Олексій Омелян, Роман Саботаш, Руслан Савельович, Лена Шевчук are present as commission members. Is the composition of the commission clear to you? Your rights. You have the right to recuse, submit motions, challenge the decisions of the Commission, voice your opinions and objections. No new materials are being considered, only those that the candidate had possibility to submit in the required deadline. If the new materials can impact the candidate's profile, then with the approval of at least 3 members of the Commission, such new materials can be included to the case file. Are your rights clear to you? Yes, they are. Do you have recusals or motions? No recusals. My patronymic is Oleksiyovych and not Oleksandrovich. I may have mistaken, sorry. And I remind you of the obligations and duties of the participants of the session. And a memo is right in front of you. And you got the floor, Mr. Reporter. Hi.
Mr. Chairman, just to let you know that Gabrielle is now on the video.
Thank you. Gabriela has just joined us. She is a member of Public Council of International Experts. So be welcome. Vitaliy. So my report on your profile. And in case you have clarifications or contributions, you can make them after. So Koryahin Vitaliy has a degree as of 2004 in law issued by Kharkiv Academy, named after Yaroslav Mudry. Professional activities, professional experience. December 2003, Vitaliy started working in Ternivsky court, Dnipropetrovsk Oblast, and he worked there until 2010, more than 6 years as assistant judge. In February 2010, he was appointed by the president's order. In February 2010, he took the office in Terniv court for 3 3, 2, 1, broadcast is back. Thank you. So we shall continue. 2017 November 2, this is the date of the president's order that appointed Vitaliy Koryahin, the judge in the mentioned court, without deadline. And from 2020 to 2023, he was elected the chair of the Ternivsky court in Dnipropetrovsk Oblast. He ran in competition to be the judge of the Court of Appeals, but was not admitted to the second stage of the competition. And regarding the score for the position of judge, Hague judge, February 4, 2026, the results were adopted, and Koryahin Vitaliy was admitted to the second sage of the competition, and the general score of the candidate is 347. A special check regarding the candidate has been made, and requests to state bodies have been sent. In particular, and also CSOs have submitted their statements. In particular, Transparency International and Avtomaidan NGO, they have submitted their statements regarding the candidate, and answers to these requests, to the statements, have been sent by me as a rapporteur, and the candidate has provided additional explanations to these requests by sending his explanations to the Commission, where he covered the questions made by the Commission and the questions made by the CSOs. Thank you. Report is complete. And Vitaliy, do you have any clarifications or contributions? No contributions. Then over to you. Then over to a Public Council of International Experts. Robert, over to you.
Thank you, Mr. Chair. Mr. O'Sullivan. Judge O'Sullivan.
I'm prepared. Good afternoon, Vitaliy. We're going to use first names here, if that's okay with you.
Okay.
And let me introduce you to the other members of the international panel. To my right is Robert. Robert is our chairperson and a lawyer in the Netherlands. And sitting next to him is Norman. Norman is a lawyer from Estonia. If you look up at the screen on the bottom left is Mary Butler, who is a prosecutor in the Department of Justice in the United States. And next to her is Judge Gabrielle, Supreme Court judge from Lithuania. And my name is John. I'm a retired judge from the United States. So before we get started, I want to ask you some questions about your finances, but I'd like to first have you very briefly tell me what it is about your work as a city judge or your life experiences that has prepared you to become a hack judge.
Щодо цього я можу зазначити, що саме корупційних
I can say that
я розглядав небагато.
I did not consider too many anti-corruption or corruption cases, just 2 for the record. Then I have been an investigative judge in some cases, criminal cases. So I have experience in this, and I have also had cases of administrative offenses. And currently, since 2022, I have had a workload, significant workload, because in Ternivsky City Council, I was just one judge, and I also had to deal with cases from district court in Luhansk Oblast. In 2023, my workload was 200%. In 2024, the workload was 250%. And next year, my workload decreased because my colleagues joined me. I have considered cases in absentia regarding corruption, and among 70 cases I considered and made judgments in 40 cases. They were not all of them were appealed, but no case was cancelled for the record. So I believe in 16 years of my practice as a judge, I have gained certain experience. I have received trainings. I also improved my knowledge, and I review the court practice of the Supreme Court, in particular in corruption cases, so I have some knowledge and experience.
Thank you. I want to first talk to you about your car that you purchased in 2018. That's a 2013 SsangYong Corando car that you purchased for 290,000 hryvnia. Do you recall that?
Yes.
And in that same year, in 2018, you earned your annual income, or your whole family's annual income was 443,000 hryvnia before taxes.
Так.
Yes.
So tell me, how were you able to purchase that car with your family income being at that level, and where did you get the funds from?
With respect to this, I've provided my explanations in writing. I would like to say that according to paragraph 48 of filling in of the declaration, the declaration is filled in with respect to funds that you have remaining if they exceed 50 subsistence minimum. As of the end of 2017, we had some savings. My wife and I had some savings, but in total, they amounted to 150,000 hryvnias. So, approximately, I had about 76,000 hryvnias, and she had about 73,000 hryvnias, more or less. But in total, the amount was 150,000 hryvnias. Accordingly, we had that amount. My income for 2000, my income to accumulate funds for 2014 was 194,169,000 in 2015, then 186,000 and in 2016, and 244,000 in 2017. And accordingly, in 2018, it was 361,000 hryvnias. So that's before taxation. My wife's income was also provided by me since 2012 until 2017. She did not have a significant income, but she still had an opportunity to accumulate her fund. My income, after already deduction of taxation, was 296,000 hryvnias, and accordingly, if we add up her income and my income after deduction of taxation, that it was 341,000 hryvnias plus 150,000 of funds remaining as of the 31st of December 2017. And accordingly, if the deduct the value of the car, then we have 201,313 hryvnias. And if we divide it by 12 months, then approximately 16,759 hryvnias we had per month for our family's life.
How was your wife employed in 2017?
In 2017, my wife worked as an attorney. She engaged in independent professional activities.
And her salary was, before taxes, was about 83,000. After taxes, about 74,000. Does that sound right?
No. I mean that she accumulated her savings not during 1 year, but starting from 2012 until 2017. Mostly my funds were spent, and she was accumulating her funds as savings.
Okay, but that was her income in 2017, correct? 83,861?
Yes.
But you're saying that the $73,000 or $74,000 that she had saved over several years. Is that correct?
Yes.
Okay. Let's turn to a garage that you use in the city of Turnivka. That is an unauthorized structure, correct?
Yes.
And what's your legal basis to use the garage?
No legal ground.
But do you pay for the use of the garage?
Ні.
No.
Даний гараж є самочинна
This garage is an arbitrary structure. The land plot for the construction of garage was not allocated. That's why there are no legal grounds to pay for the land plot or for the garage. I've mentioned that in this garage is declared by me since I used it so that external observers would not have questions as to why I did not declare it. Because I was using a car for some period of time. That's why I declared after that I started using the garage as well. This garage before me was used by my sister, and before that by father.
Is it located near your home or near your work?
У нас невеличке місце.
We have a small
Містечко
town.
невеличке взагалі.
Small town.
Так, він ближче до
Yes, it's closer
ближче до моєї
to my place of residence.
And can you describe the garage for us? Is it a building? Does it have a roof and a floor or side walls?
Так, є дах, є
Yes,
стіни.
there is roof, there are walls.
Це стіни, саме
There is everything like wall, roof, at the garage. To say that there is something else apart from the garage, no, nothing else inside the garage, just to put a car and that's it. I've also mentioned that right now the head of Suputne Cooperation is dealing with the possibility to legalize this garage. In our town, approximately, I cannot tell you, but we have about 1,000 of garages that have been arbitrarily constructed. And the issue of demolition has not been raised by the city council, no. All the heads of associations and corporations are dealing with that because they were constructed back in 1997 until the year of 2000. And with respect to the garage that I'm using as well, the local council has never raised the issue of demolition, and there have been no claims regarding that. But that is an arbitrarily constructed structure, yes, according to Article 376 of the Civil Code.
Did your family construct the garage or spend money on the construction of the garage?
Ні.
No.
Ні я.
No, neither I nor my family spent money on the construction of this garage. But I'm just saying that otherwise it was impossible to declare this garage in the declaration. Because if I do not put the mark that that is a constructed garage, the declaration would not have led me to enter this fact. And I wanted to notify about this fact, that about the use of this arbitrarily constructed garage. And there is also no opportunity to add the note that it has been arbitrarily constructed.
What prevents anybody else from using the garage?
На даний час тільки я користуюсь.
Right now, only I'm using it.
No, but what would prevent another person from parking their car in that garage?
Ніяких.
There are no obstacles. It's possible. If due to legal grounds, yes, anyone can use it because that's an arbitrarily constructed garage. There are no legal grounds not to allow that. And my father and my sister did not have that because the land plot was not allocated and the permission for the construction of the garage was not issued either.
And your position as a judge, does that have anything to do with your use of that garage? Were you being allowed to use that garage?
Я розумію,
I understand that that's not correct, that I'm using arbitrarily constructed garage. But I would like to point out that in our particular town, we do not have any, we have only about 150 legal garages, and the rest of the garages are arbitrarily constructed. So either I should not use any garage and park my car by the house, or I'm using this garage.
I'd like to move on to a apartment that your mother owned. with an area of 36.4 square meters in your town of Ternivka. And it was acquired by her on January 28, 2010, by court decision from you, who was the previous owner of the apartment. Can you explain to us why your mother had to sue you to obtain this apartment?
Щодо цього я вже надавав
With respect to that, I've already provided explanations to the members of the HQCJ, and I can also say that in 2005, I did not have income to buy an apartment. I did not have, and my mother was given funds to buy the apartment. My parents had these funds for that. And since, and with respect that she gave funds not to me, she wanted to do that on her own. But back then she was sick and she didn't have a chance to come to the state notary to conclude this agreement. That's why, since she liked the apartment in terms of its location, because it was close to a hospital, and she also liked the price of that apartment, and that's why she gave me funds, and she said that I was supposed to buy this apartment. She allowed to include my name into the sale and purchase agreement as the buyer of this apartment. In 2009, I was also mentioning that our parents' relationship worsened. It happens. I cannot tell you. In my opinion, I do not want to say. They just worsened back then. And she said that she wanted to live in this apartment. It's a one-room apartment. So 3 adults and 1 child, which I had back then. It was impossible to live in this apartment altogether. And our town is small. And back then my wife and I worked in this town. And it was very, very difficult to find another apartment. So I had some conflict. Yes, on the other hand, I have a wife with a child who do not want to leave the apartment. And on the other hand, I have my mother who wants to move into this apartment after the worsening of her relationship with my father. And that's why I said that this issue should be legally decided, and she filed the claim. Her claim was satisfied, and she was specified as the owner of this apartment.
And she originally purchased that apartment in 2005 for 20,000 hryvnias. Is that correct?
Yes.
And in that same year, she earned approximately 16,000 hryvnias and earned 9,000 the year before and 6,000 the year before that.
Yes.
Did you provide any funds for the purchase of the apartment?
No. With respect to funds, I can explain that back then I moved from one place of work to another work. I became the assistant of the judge. And my total income, according to the statement provided by the NABU, was 3,000, if I'm not mistaken. Back then, as an assistant of the judge, I got 289 hryvnias per month. So I did not have income as such. I did not have an opportunity to contribute to that. Back then, even my wife was getting more than me, twice as much as me. And that's why we use these funds for living, and that's it.
You presently live in a apartment that your mother owns, a larger apartment, about 70 square meters in the same town, correct?
Yes.
And that apartment was purchased for about 80,000 hryvnias in 2010?
Yes.
So some of that money came from the sale of the smaller apartment, about half of it, about 40,000 hryvnias?
Yes.
And where did the remaining 40,000 hryvnias for the purchase of the apartment come from?
Я також щодо цього зазначав.
With respect to that, I've also mentioned that she had pension payments for 2008 to 2010, which amounted to 42,462 hryvnias. Pension payments are not taxable. Besides, I've also mentioned that she had remaining funds from salary for that period of time. So she had money to buy the apartment. The salary as of 2008 was 16,592 hryvnias.
So let's move on to another topic. In 2025, the Human Court of the European Court of Human Rights found a violation of Article 5 of the Convention and found that you allowed excessive length of detention and awarded a judgment of 2,700 euros. Are you familiar with that case?
Так, я її
Yes.
зазначав саме.
I mentioned in my application.
And were disciplinary proceedings initiated against you in connection with these facts?
Щодо мене не було.
With respect to me, no, there was not disciplinary complaint submitted. But regarding that, I can explain
Okay.
that in this case,
Можливо пояснити, так?
can I explain? Yes.
Yes, yeah.
Щодо цієї справи, я можу
With respect to this case, I can specify that this case was under Part 3 of Article 307 of the Criminal Code. There was the sale of psychoactive substances by the organized group during a long period of time in our town. That was investigated not even by our law enforcement body, but by a regional law enforcement body. And they committed several criminal offenses, and the case was concerning 3 persons. Before me, another judge of Ternivsky City Court adopted ruling twice on detention. After the expiration of powers, the case was transferred to me, and during the preparatory court hearing, I extended the term of detention for 2 more months. So that is for 6 months in total. After that, I adopted the ruling. I returned the bill of indictment because I thought that it did not comply with requirements of the Criminal Procedure Code of Ukraine. And after that, once my ruling was cancelled, since it was stipulated in the ruling of the Court of Appeal, because the prosecutor can change circumstances in the bill of indictment during the consideration of the case, I recused myself, and my self-recusal, since I specified shortcomings of this bill of indictment, my self-recusal was satisfied by a judge of another city court. And then this case was transferred to another judge by Dnipro Court of Appeal. So I only once extended the detention period for 2 months. After me, judges of the Dnipro Court of Appeal extended the term of detention for 2 months. And once the case was reallocated, the judge of Pavlograd City Court extended the period of detention 18 times, every time for 2 months. With respect to circumstances as to why I extended the period of detention, I've mentioned that it was the preparatory meeting. In the motion of the prosecutor, it was specified that this person knew the witnesses, that this criminal offense was continuing, and it was committed during a long period of time. And Part 3 of Article 307, that this offense was committed by an organized group. And based on these facts, I extended the period of detention, taking into account all the factors as to whether it was possible to release them or no. And I decided that it was impossible to release them back then. So I clarified that there were risks envisioned by paragraphs 1 to 3 of Part 1 of Article 307 237 of the Criminal Code. But since in this case, I'm one of the several judges who extended this period of detention, and that's why I mentioned in my application that there was the decision of the European Court of Human Rights. In order to avoid among external observers an impression that I'm not mentioning these facts.
Oh, thank you. So this next area I want to talk to you about recently came to our attention from Transparency International, and I don't believe that we sent you any questions on it, but in 2017, a person named Vasyl Shibanov filed a disciplinary complaint against your actions as a judge, stating that in October 2012, you ruled in a case regarding him in 22,000 hryvnia, and that your wife had previously represented his ex-wife in a related divorce proceeding. Are you familiar with that case?
Yes, I do. It was about property division, not divorce.
Okay. And was your wife at that time was a lawyer, and did she represent the former wife of this person?
No, in that case, my wife was not involved. She did not represent the claimant. So do you want to go in more detail? Can I?
Yes. Well, let me ask you, did your wife represent the claimant in a prior action with the husband?
Before, yes, once.
And were you aware of that when you were considering the newer case?
Yes, I did.
Okay, so explain to me why you thought it was proper for you to rule in that case.
Щодо цього можу зазначити про те, що дана
I can say that that civil case where I ruled out was not connected to the previous cases where my wife had represented the claimant. So those cases were completely unrelated. That civil case arrived at my office, and the High Qualification Commission sent that request from the civil society organization. I don't have copies of all the cases, but I have a copy of that case. So that was a civil claim signed by the individual. The individual submitted the claim themselves, and the defendant received the claim, and I delayed the consideration of the case. I put it off following the defendant's request, but in the end he did not show up. And within that time, if the defendant believed that I could be biased, he could use recusal, but he did not. And that civil case, so by the end of the civil case, no appeal was submitted. I know that between those individuals, there were other cases. My wife did not represent interests of either of them. Other attorneys represented their interests. My wife was not involved in that. And it is unclear why in 5 years he submitted a disciplinary complaint against me. The materials of the civil case are available, and I've got them. I have copies in order to confirm that my wife was not representing the interests of either party. No orders, no instructions, no applications from her.
But to be clear, your wife had represented one of the parties previously. Is that correct?
Так.
Yes, this is correct.
And what is the status of that complaint?
Вона була залишена без розгляду, оскільки він подав
It was left unattended
через 5 років.
Because he submitted this appeal 5 years after the verdict, the judgment. After that civil case, I did not rule out in any case that involved him and with the other party either.
There's been no decision on the complaint?
Вона залишена так. Є рішення, вона залишена.
There is a decision by the High Council of Justice. It was decided to leave it unattended because of the statutory limitations.
Okay. Do you know that the complainer in that case says that he appeared in court, but that you indicated that he did not appear at the court hearing?
Щодо цього я можу зазначити про те, що його не було.
I can say that he did not appear in court. So we're talking about the defendant. The defendant did not appear in the court, and the claimant did. So the claimant appeared in the court, and he wanted to have an in-person hearing. And the defendant appeared in 2 years after the session, and I had already ruled out and switched to other cases. So he came late to the court session, and he was late by 2 hours. He was 2 hours late.
All right, let me move on to when were you appointed the chief of your court?
Just a moment. I was appointed the chief in 2017, November 16.
And how long did you remain the chief? How many terms?
Відповідно до закону, двічі поспіль. Я 16 листопада 2017 року,
2 times in a row, from 2017 to 2020, and then from 2020 to 2023. And because I couldn't remain in this position, we needed to have elections again, and I could not be reelected the third time because it doesn't go in line with the law.
But were you the acting chief for a while?
Так, я був виконуючим
Yes,
обов'язки голови.
I was acting chief,
голови в Тернівському міському суду не
and
передбачена. У нас
there is no deputy chief. We only have 4 judges in the court.
And when did you become acting chief?
Можливо, більш детальніше пояснити щодо цього.
Could I explain it in greater detail?
Sure.
Щодо цього зазначаю про те, що 1
So,
серпня 2021 року
August 1st, 2021,
до цього правосуддя було 3 судді.
we carried out a justice. There was 3 of us. Then, in September 2021, another judge terminated their contract, and by the end of the year, another judge terminated their contract, and I was left alone in the court. And all the others could not exercise the judge's duties. So there was a judges meeting in November 2023 in order to elect the chief, but no candidacies were proposed because I could not take this position the 3rd time in a row, and other judges didn't have the right to do it either. So therefore, it was decided in November 2023 to charge me with the duties of acting chief because I had a bigger experience, and that was in line with the law on judges and status of courts.
And are you still the acting chief?
Ні. Я також про це зазначав.
No, I also indicated that.
Відповідно до цього, указом президента України
According to the President's order, October 8, 2025,
вже безстроково судді Соколова і Солодовник.
Sokolova and Solodovnik, these judges, took office after training and after vacation, and in October 2025 and in November 2025 they took office, and in December 2025 we had judges gathering in order to elect the chief, but no candidate had a sufficient score to become a chief. And December 25, 2025, another judge gathering was held, and in short term I scheduled this meeting, and Sokolova was elected the chief. And since December 26, 2025, she is the chief. I'm just a judge.
And your son works for the district court, is that correct, in your same region?
Yes, this is correct.
He began as a clerk from October of 2024 to November of 2024?
Ні. Він
Not exactly. He works in the Dnipro district court, Dnipropetrovsk Oblast. It's about 110 kilometers from my place of residence and my court. He started as a secretary of court session and then as a clerk, yes.
And then he was shortly after appointed as an assistant judge at that same court?
Yes, correct.
And how was he able to obtain that position of assistant judge, having been a court clerk for only a month?
Щодо цього можу зазначити, що
Here I can say that currently there are many vacancies for both clerks and assistant judges because the salaries are very low, and that is a well-known fact. And this is why there were vacancies for assistant judges position. And he was appointed as the second assistant judge. And that judge had a very high workload in that court. And in fact, it was a probation testing period. because usually assistant judges are appointed following the instruction of the judge. And for 3 to 4 months, he was second assistant judge. They tried and tested him as an assistant judge, and a different judge recommended him to that position. And now he is the main assistant judge.
And did you have any influence on him receiving that position?
Ні.
No.
Okay. All right, thank you. I don't have any further questions at this time.
Thank you, Mr. O'Sullivan. Mary, Gabrielle, any questions? Yeah, I have one question for you. Let me see where I am. It's about the apartment of your mother where those proceedings took place. There was proceedings about it, and you explained, I believe, that this apartment was bought with money that your mother gave to you, and because there were issues with your mother's health, she was not able to receive it or to obtain it. It was written or obtained in your name. Is that correct? Is my understanding correct in that respect?
Це щодо квартири, яка була придбана у 2005 році, оскільки мати...
Is it about the apartment bought in 2005? Because my mother bought two apartments in different periods.
That's apartment. It's about the court decision of 1st December 2009. Yeah, and I understood that that she gave you the money. She was sick. She was not able to obtain possession of the apartment, and then it was, let's say, obtained in your name. Is that correct?
Ні, не так.
Not exactly. So I indicated that back then she could not appear, she could not come to the state notary office because she was sick. But she wished,
Yes, and then because then you registered.
She
wished that that apartment should be bought. She wanted to buy that apartment. The location was good and the price was good.
Why was it then registered in your name with the notary public?
Оскільки вона не мала можливості з'явитися до
Because
державного
my mother couldn't come to the state notary. According to Ukrainian laws, we need to come to the notary office, and this is why she gave me the money.
Yeah, I understand that because we have the same system. You could have had a letter of authorization from your mother. Or was that not possible?
Це ж знову їй потрібно було з'являтися до державного.
That would mean that she would need to appear at the notary's office.
Okay. But between you and your mother, as from the beginning, it was clear that it was her apartment.
Надавала кошти і бажала сама придбати дану квартиру.
So she wanted to buy this apartment and it was her money, but because she was sick, she wanted me to become the buyer, the customer, because I am her son.
Yes, but the question was between you and her clear that it was her apartment? It was registered in your name, but she gave you the money. She wanted to buy it. She gave you the money. Yeah. Yeah. And then I don't understand.
Її квартира.
Then I don't understand.
Yeah, her apartment. It should have been her.
Yes. Then I don't understand why there was a need to go to court, because then she says, I want my apartment. And then you could just turn it over. to her. Why would you go to court? I don't see that. I don't understand it. And what I find strange is that you don't appear in those proceedings.
Ну, щодо цього я можу зазначити про те,
Well,
що
here I can say that I worked in that court,
тому підписав саме я на
and therefore
позовну заяву і написав, що розгляд відбувався за моєї відсутності. Щодо цього, я так
the session, I asked that the session be held without my presence. My mother wanted to live in her apartment, but my wife did not want to leave the apartment. And living in a one-bedroom flat for 3 adults and 1 child would be problematic. And there was a conflict already between my wife and my mother, and that's why I mentioned that that issue needed to be settled down through court, so that there are no questions about this apartment and the ownership.
But if I look at the court decision, I don't see that issues are settled in the court proceedings. Because you don't appear. And the court says, well, the mother says it's her apartment. You don't say anything else. And then she gets the apartment. So nothing was settled there.
Ні, в судовому рішенні
No.
зазначено про те,
In the court decision, it is stipulated that she took part during the consideration of this civil case, and my wife took part, who did not want to move out of this apartment. I did not take part in the court hearing due to the consideration that I was working in that court in order to avoid any bias. That's why I submitted an application on consideration of the case in my absence. And since I knew about this fact that my mother was giving money to buy this apartment, and I admitted that in the claim.
Okay, thank you. No further questions from me, Mr. Chair.
Дякую, пане голово.
Thank you, Mr. Chair.
Будь ласка.
Mikhailo, please. Vitaly, I have some questions from me. I've also studied the dynamics of your savings and the purchase of objects which were mentioned in the request, and which we just partially discussed. That's about the vehicle, the use of the garage, purchase of some real estate objects with legal consequences of the decision of the European Court of Human Rights. And I would like to discuss some matters in more detail. As I mentioned during my presentation, from 2003 until 2010, you worked as the judge's assistant in Ternivsky City Court, right? Yes. With which judge did you work? In Ternivsky City Court. Which judge did you work as an assistant? Which judge? With respect to that, I can say that I was appointed in 2003. There was a competition, and with respect to that, it was not determined. Mr. Vitaliy, I remember the legal status of the judge's assistant. Indeed, for some period of time, the judge's assistant was not considered as civil service, etc. But after all, the judge's assistant always performed instructions from a specific judge and worked with a specific judge, even when the assistants were civil servants. With which judge did you work? With Judge Morozova, with Judge Stukovenko, with Judge Tkachenko. Judge Zhmailova. Did you work with Judge Zhmailova? With respect to that, I can say that I did not work with her, but for some period of time, when the judge was on sick leave, I was performing duties. During which period of time did you perform functions of the assistant? At the very beginning of my appointment. If I'm not mistaken, that was 2007. As of the moment of consideration, I did not help her with drafting any drafts I was performing instructions of the president of the court. You understand. As of the moment of consideration, you mean the case with your participation? By Judge Mylova, judge of Ternivka City Court, where you work. Judge Mylova considered the case on the 1st of December of 2009 that was adopted the judgment. A lot has been already mentioned about this dispute. I would like to hear your opinion as an experienced lawyer who has held the position of the judge for over 15 years. From the civil legal perspective, how would you qualify this legal relationship that emerged as described in this situation? In your opinion, are there signs of artificial legal transaction? With respect to that, I cannot. That's another judge who took the decision. The Code of Judicial Ethics does not allow me to comment on the decision of another judge. Sorry. Okay. I will model the situation. In 2005, okay, we'll try to briefly recreate this fact. In 2005, you got 20,000 hryvnias from your mother for the purchase, as you are saying, apartment, right? Yes. In 2005, you, as the party to the transaction, conclude the sale and purchase agreement for a real estate object valued at 20,000 hryvnias. And the price of the apartment was lower. Okay, 15,000 hryvnias plus registration. Yes. You obtain the status of the owner of this object. The right of ownership is registered in your name. Yes? Yes. In 4 years after that, in 2009, mother is submitting a claim to the court on recognition of this transaction as artificial and on recognizing her right of ownership for this apartment. You are the respondent and your wife who lived in that apartment. Since your mother is referring to the fact that in 2005, she wanted to become an owner, and for that purpose, she gave you money so that the agreement would be concluded in her interest, but because of the health condition, she could not be present during the conclusion of that transaction. And actually, that became a ground for reaching a conclusion about the artificial nature of this transaction, right? I cannot set court decision. Now I'm asking about the legal position of the claimant, which was expressed back then. I understand from the decision that was adopted and that was published in the Unified Register of Court Decisions that yes. Understood. And what was the dispute about? What was the essence of the dispute that was considered by the court? What were the signs of that? What was the violation of substantial or some other interests of the claimant? I cannot say that because I was the respondent under the case. I was not drafting this claim. Another person was drafting it. I was the respondent. Okay. But I specified the grounds that my wife did not want to move out of this apartment because in my town, back then, it was very difficult to find apartments. Okay, and your position is understood. The nature of the relationship is understood. I would like to clarify whether you worked with Judge Shmylo, who adopted the decision back then. You said no. And actually, okay, your position is clear about this object. With respect to the object, that is unfinished construction object that you declare, we are talking about the garage, right? Tell me, please, what is the legal mode of the land plot on which this garage is located? It is owned by the city council, by the community of the city council. Okay. You are declaring this unfinished construction object. And what about the land plot on which the object is located? I'm also specifying that it is owned by Ternivka City Council. The declaration mentions that. Okay, what is the area of this land plot? I cannot specify that because it is not determined. And there is no number of garage, no location of garage, nothing. It's an arbitrarily constructed structure. I cannot declare that. Okay, your position is clear. Use of real estate objects owned by the territorial community. Is it a ground for the emergence of some duties, in particular payment for the land or tax? No, there are no legal grounds for the payment of taxes because the land plot under this was not allocated for the construction of garages. Right now, this issue is being resolved by the head of garage cooperative Suputnik. Okay, thank you. You are always emphasizing that you specified something in your explanations, but you should probably understand that we have to publicly discuss all of these circumstances. Yes, thank you, sorry. I'm asking that not because I didn't look through your explanations, but because we have to, after all, discuss that publicly. Actions did you commit in order to obtain respective property rights for this land plot and to legalize the unfinished construction object? Sorry, I understand that I have to answer. I will answer. Now I understand that I should not refer to my written explanations. With respect to your question, I've already mentioned that I specifically did not take any measures. That is being resolved by the head of garage cooperative Suputnik. He is resolving the issue on allocation of the land plot because not only my garage is located there, but there is a number of garages. Approximately 200, 300 garages are located there, and accordingly, the land plot has to be allocated for all the garages. So separately, I cannot submit an address to the city council to request to allocate the land plot for my garage. It should be allocated for all the garages located on that plot. During which period of time have you used this land plot? If I'm not mistaken, as I have mentioned, starting from 2016. 2016. Clear. Thank you. With respect to this situation, with possible conflict of interest in your activities that was discussed, and that is related to the participation of your wife in one of the cases. Let's come back to that matter. Which cases did you have in your proceedings back then? One of the cases was on the separation of property of the married couple, and the other one was about unjustifiably received funds. Which of the cases did you consider? The case on separation of property was considered by another judge, where my wife was representative interest, and I was considering the case on financial assets. Were these cases related? No, in my opinion. Were the parties to these cases the same? Yes. Your wife was a representative of who of the parties? No, she was representing only the claimant. She could not represent her respondent. That's why I'm asking which of the parties she was represented. Claimant. In the case that your colleague considered. Yes? Yes. And actually, the same person was the party to the case that you were considering. Yes, she was the claimant. And during the consideration of the case by you, your wife had an ongoing legal aid agreement with the claimant. No, it was concluded only for one case, for the separation of their property. So basically, contractual relationship existed, but they were not applicable to the case that you were hearing. They terminated with the consideration of the civil case on the separation of their property. So back then, when you were taking the decision, when you were hearing the case, there were no contractual relationship between your wife and the claimant. Yes, yes. They terminated after the case consideration. And the contract was concluded for a fixed term or for the consideration of this particular case on the division of their property. And it was considered back in 2011. I was considering the case in 2012. Thank you. With respect to decision of the European Court of Human Rights, in attachment to this decision, in the part that can be related to you, with respect to Koldunov. Yes. There are several grounds that actually, to which the European Court of Human Rights referred to as the ground for the conclusion of the failure of the state to perform its commitments under Article 5 of the Convention, right? Yes. And with respect to the defendant, it is sad that in the ruling on the interim measure, there were grounds that lost their topicality, grounds were of general nature for several persons, and grounds actually were not up to date. And the general nature of these grounds applicable to several persons. What was the reason for such conclusions? You explained the situation in more detail. You mentioned that the interim measure was selected by one court composition, then it was extended several times. When you were taking the decision, circumstances related to Article 177 were the same or different? In my opinion, they remain the same, because I received the case, I conducted the preparatory court hearing, none of the witnesses was questioned. This person, for a long period of time, were selling drugs. The prosecution was under Article Part 3 of Article 307 of the Criminal Code, and the sanction was 12 years of imprisonment with confiscation of their property. They committed several criminal offenses under the one qualification, and there remained the risk that they would continue committing the criminal offense. Moreover, I would like to say that these persons submitted an appellate complaint against my ruling, but the Court of Appeal remained it unchanged, left it unchanged. Okay, thank you. Tell me, please. The crime was committed by a group of people, right? By an organized group. In your ruling, did you motivate risks with respect to each of the accomplices? Yes. And your ruling was left without changes by the Court of Appeal? Yes. Okay, it's clear. In this regard, and tell me also, please, in your integrity declaration for 2024, you declare the instance of the conflict of interest and its settlement. Which conflict of interest are we talking about, and how did you settle it? With respect to that, I can mention that in clause 10 of the Integrity Declaration for 2024, I requested self-recusal in the case. And that's why I mentioned in my Integrity Declaration that I'm confirming that. That was the answer regarding the explanations of filling in of the Integrity Declaration. Okay, understood. In writing, I was asking you about statistics of recusals and self-recusals under cases that were considered by you as the presiding judge. In one of the cases, you provided information I'm talking about case 194 with 16K at the end. It is mentioned that after the determination of the jurisdiction, the case was returned by by the Court of Appeal, and you, as the judge, considering this case, submitted a self-recusal motion. The justification of the motion on self-recusal was that the representative of the defendant, of Borovenko, was your wife, Koryahina, which is a circumstance that excluded your participation from the consideration of this case. However, your motion as the judge of Ternivka City Court, Dnipropetrovsk region, was denied in satisfaction. Do I understand that correctly, that in the criminal proceeding, the defendant's representative was your wife, right? Baranenko was the defendant. The verdict came into effect, and the representatives of the defendant was your wife, and your wife submitted a claim on the explanation of the verdict. No, the defendant submitted an application, but back then, actually, your wife was the representative of this person. No, but you just said yes.
You just said it. Yeah, I got it. She represented the accused as a representative of the center, legal center. And there, she was acting on the instruction from them. And because she defended the suspect at the time of pronouncement of verdict, I could not influence it, but the judge of Pavlohrad District Court mentioned that there is such a practice of the Supreme Court when the service of the verdict is not impacted by the judge. And so it was a reference to the Supreme Court practice. At which point, in your opinion, your wife ceased to be the attorney of the suspect? When I did self-recusal, I believe that self-recusal was still effective by the end of the proceedings. So your wife was granted the right to defend Baranenko. The court charges Baranenko, wife defended the interest of Baranenko. Then Baranenko asks you to clarify the verdict. You receive this request. You make self-recusal. Is this correct? The chronology of it? But in your application about self-recusal, you believe that relations between Baranenko and your wife continued? Yes. When I made self-recusal, I believed so. The other court mentioned that there is a practice, the Supreme Court practice, that I can consider this case. What was the instruction? What did it say about the instruction about free legal assistance? It said that assistance was provided until the last procedural stage. So my wife would accompany this party with the cassation court, etc. Okay, your position is clear. So you considered the defendant's request, and who prepared the request? Was it your wife? No. that request arrived from prison, and it was signed by the accused. As I said during my report, most of the facts were discussed. Statements from the CSOs. One of the statements came from NGO Transparency International Ukraine. This statement relates to your one of your cases, administrative cases, Article 130 of the Administrative Code, and we cannot doubt of the motives and circumstances of the decision, but probably the problem pointed out by Transparency International lies within a court mistake. How would you comment this? Clause 2 of the statement. Regarding the administrative offense, I can say that back then we had Article 286, Part 1, where there was no mention of state of intoxication. There was a scale of injuries, light, medium, heavy, and grave. Now, Article 86 says that all those actions committed while intoxicated are graver. So when I made the decision, Article 86, Article 124, there are circumstances to refer to Article 124, and here Article 38 is applied 1 month and 2 months under Article 130. So it was not a sign, a characteristic of the offense, so I used Article 38 because this circumstances was mentioned in the indictment, and it could be used as a aggravating factor. Law enforcement officer could use Article 130, and it is a proof to indicate an aggravating factor. We have had this issue before in the court because another colleague made a judgment, and in his judgment he used a different circumstance. Law enforcement officer, he got a paper from law enforcement officer, and he asked himself whether he could interpret it as an aggravating factor or not, or on the contrary. And in my opinion, in my colleague's opinion, we decided that there were no circumstances, and it could be an aggravating factor. Thank you, Vitaliy. So if we summarize, it is about application of law, and there is court ruling, and there is a decree that has come into effect, and your vision of the situation is clear. Just one more question. Lyudmila Koryagina, and that is a question mentioned in one of the statements. This is a circumstance that testifies to conflict of interest. Do you know this person? I know that my surname is quite well spread, and I just had a loan dispute where one of the party was Koryagina. So that person is not a relative of mine. Thank you. I've got no more questions, colleagues. Roman? So we're gonna have some questions. Sabotage, I will still have some questions regarding the situation in 2009 regarding the agreement. We will not talk about the decision. I'm interested in circumstances. You recognize the claim. Was it a pretended deal? What were the parties to that deal? You were not a party of that deal. I get your question, but I was an assistant judge, and I worked from December 2013, and I was inexperienced. Did you have a degree in law, and did you work as an assistant judge? Yes, and yes. But I had only 1 year of professional experience. From this decision, from what you said, you had monetary commitments in front of your mother, and you abused them, abusing your mother's trust. No? How so? So she gave you the money, she gave me permission to have my name included in the agreement. So how do you assess your actions? So the claim is you did not appear to the court session, and you recognize the claim in fullest. So I'm not asking about your attitude towards this claim. I'm not evaluating the court decision either. And as of today, I understand that there may have been circumstances regarding this decision which I cannot disclose now. There were also statutory limitations there, but you recognize the claim. Why do you think the claim was submitted in the first place? I cannot say it, and I indicated what I could. So here it says that your family relationship got worse, your marriage, and in fact, so it was a kind of property division in case marriage would be, in case you got a divorce. So my wife recognized this. I know, and it couldn't be qualified as pretended deal. My wife was aware of the circumstances. In 1-bedroom flat, having 3 adults and a child, that's too much. A young family and a mother is bound to end in a conflict, and I realized that, and this is why I knew that we needed to settle it legally. So your position was that currently the relationship with your wife got worse. Yeah, there are mentions of that. We had a good relationship with my wife. Our relationship with my mother got worse. So I, on one hand, have my wife with our child. On the other hand, I have my mother. I couldn't choose between two loved ones. And I indicated that because it was known, I recognized the claim, and I was not a party to this civil case. I'm not asking whether you took part in the proceedings. I'm just interested in the characteristic of those events. We're not evaluating them. So you were assistant judge. This is a fact. And you already provided your evaluation. Thank you. And if you have questions, go ahead. Vitaly, try to give brief answers. Just one quick question regarding this apartment. Why, when you concluded an agreement of sale, why your mother did not order notary, did not order instruction approved by the notary, instruction for you? It was my mother's decision to abstain from ordering such instruction. It was her decision to have me conclude this agreement. You're a lawyer. She was in a hospital. Vitaly, you're a lawyer, aren't you? Yes, I am. You know the legal nature of things. And this is something students learn in year 1 and 2. So your mother asks you to handle the sum of money equal to a object of real estate. If she can do that, that is, she needs to order an instruction, and that is not that expensive. Why didn't she? It wasn't her decision. Okay, I get your answer. There is no sense in going further into this. Since 2017 to 2023, you have been the chief, and then you were acting chief until the end of 2025. So we've considered your dossier, and you considered the judge dossier. I considered the candidate. Do you know that in your dossier and the section about judge statistics, there is no data about the time frame within which you considered cases, including the time when you were the chief. This data is provided by the head of the court administration, and I informed him of this. So being the chief, and your court is not too big, that influences the quality of judge dossier, so and so. Were you not interested in organizing the work of court administration? At that time, the head of the administration informed me of the fact that he couldn't indicate this information in all the sections because I can't. He talked to other heads of court administration, and back then many heads did not indicate it. Vitaly, so I can tell you that most judges with whom we have interviews, both during the qualification assessment and during the competition, they have failed this section. And your case, when this section is completely blank, this is rather an exception. Unless you had an administrative position, I wouldn't have asked you this question, but it is related to the organization of your workflow.
періоду мною на це було звернено керівника апарату, і він подальшому
So I informed the head of the administration about this, and later on he provided the information. And the information about the time frame within which your court considered cases,
немає значення.
does it matter in your opinion? Yes, it does. And I indicated that, and he provided the information. But the section for 2024 is blank. Do you know that? No. It was him who provided this information. He possesses the information, and he is the responsible official. Thank you, Vitaliy. I have no more questions. Maybe colleagues do.
У мене одне запитання, пане Віталію. По декларації 24-го року дохід вашої
I
дружини...
have a declaration. According to the declaration for 2024, the income of your wife from independent professional activities is 35,500. But according to information of taxation body, it was 94,400. What was the reason of that? I did not find this amount anywhere. With respect to that, I can say that she is telling me that she is declaring income with the deduction of expenses that she had for her professional activities. So what you specified in, so what you declared in the declaration, that was net income from which taxes were deducted, even though she was filing 94,000. Yes. Why then? Why do you declare your salary before taxation? With respect to that, I can say that every year I requested information from the tax inspection, and I declared information from the tax inspection that should be accurate in my declaration, correct? But she's also declaring 94,000. I understand. May I explain? Yes. I can explain that I'm submitting the declaration on the 1st of April, and she's doing that on the 1st of May. She's submitting her declaration a month later. She's telling me the amount and I'm declaring it. Okay, your answer is understood. Colleagues, no more questions, or do you have any questions? I have one. Mr. Vitaliy, another question about the declaration. From the Register of Property Rights, I see that your wife owned an apartment in the city of Dnipro at Sonishna Naberezhna Street. Yeah, she still owns. But I do not see it in the declaration. It should not be declared. It was purchased in 2025. I'm supposed to declare it in 2026. And here the date is 2021. That's not correct. I provided to the HQCSJ member and to the PCAE member information that the sale and purchase agreement, according to which it was bought on April 18th of 2025, 1,539,000 hryvnias. So please explain what operation was conducted in 2021, because the register contains the date, amount, street, but the date is in 2021. So she was selling a part of the apartment and the house. Selling? Yes. She inherited the house, she sold it, and the part of the apartment, half of the apartment that she owned in 2021. Again, in which year? In 2021. Both real estate objects were sold in 2021. But I see income from the sale of real estate object in the amount of 160,000. Yes, 65,000 was received by her and 65,000 was received by a child. The apartment is on the 5th floor. We could not live there because the roof. Let me shorten my question. If the register gives the value of 1.5 million, why we are talking about 60,000? That's in the register for 2025. Its price increased 10 times? No, the apartment cannot be 1.5 million. That's the city of Dnipro.
Вибачте, вона продавала в
Sorry.
місті Тернівка. В місті
She was
Дніпро
selling in the
договір
city of
продажу
Ternivka.
18 квітня 25 року.
But the sale and purchase agreement in the city of Dnipro is dated 2025. But why does the register specify it's 2021? I understand your question. Before that, I just misunderstood. That's not my wife. That's a child. I made a gift to the child, and the apartment of the child was bought in 2021. My child. Do you have that apartment in your declaration? Yes, and I'm declaring it. At Sonячна Набережна Street. Yes,
Я зазначаю про неї. Вона є.
I'm declaring it. You have it in my declaration.
І також я щодо цього
And also, with respect to that, I mentioned income, etc. for the resident of this apartment. Okay, understood.
Якщо запитань більше немає,
If there are no more questions,
у громадської ради між
what about the PCIe members?
One question,
Yes.
please.
Joe, thank you.
One follow-up question. After the court ordered that your mother had ownership of the apartment in 2010, did you and your family continue to live in the small apartment?
Ще, будь ласка, я просто не почув. В
Can
якій
you
саме
please repeat, because I did not put on the headphones. In which particular apartment? Can you please repeat?
After the court ordered that your mother had ownership of the apartment in 2010, did you and your family continue to live in the small apartment?
Суд вирішив в 2009 році.
The
Ми
court
після цього
adopted the decision in 2009, and we did not live in that apartment after that. We moved to a rented apartment. So we were renting an apartment after that.
Subsequent to that, you moved into your mother's larger apartment that she had purchased later in 2010?
Так, в грудні
Yes.
13 року.
In December of 2013.
Okay, thank you.
Отже, запитань більше немає. Віталій
So
Олексійович.
there are no more questions. Mr. Vitaly, now you have a chance to address us up to 1 minute.
Можливо, ще не зазначили комісії.
Maybe you would like to add
Громадській раді
something
міжнародних експертів.
for the Commission and the PCIe.
Я дуже вдячний за...
I'm very grateful for the competition. I'm proud of taking part in this competition for the position of the judge of the HUB. Thank you. Thank you for your participation in this meeting. With respect to you, the interview is over. And since we've exhausted all the items from our agenda for today, I'm announcing the special joint meeting over. Thank you, everyone,